But what we're doing this morning is having a trial regarding the outstanding issues that we ended on from July 31st, 2023. The court specifically reserved at that time the issues of permanent spousal support, child custody, division of EPAM employee stock, and each side's request for attorney's fees. So I ask again, Mr. Mars, at this time, are you ready to proceed with the trial, or are you objecting to proceeding with the trial because of your concerns about the court, what you perceive as the court's conflicts?
Your Honor, I state on record that we cannot proceed because you, Your Honor, has personal conflict of interest with me as petitioner in this case, and legally obliged, according to CCP 170.1, Section 6A3 and Section 3A, to recuse due to direct impermissible conflict of interest with petitioner who is party on this case. Thank you, Your Honor.
Thank you. Thank you. So the court has responded in writing repeatedly to your request that the court recuse itself and your position that the court has a conflict. The court has stricken each of those requests, and the court is prepared to proceed with the trial. So are
Objection,
there
Your
any, is there any other reason besides your concerns about the court's ability to be fair? Do you have any other reason why you cannot proceed with trial today, Mr. Mars?
Yes, Your Honor. You are investigated by government authorities for bribery and severe intentional repetitive misconduct. This hearing is recorded and will be used by prosecution. I'm stating clearly that this hearing starts from the moment after which your orders do not have legal power, because your orders are driven solely by desire to retaliate me for reporting you to government authorities. And by the law, judge who has personal conflict of interest is required to recuse.
Thank you. So you're repeating yourself now, Mr. Mars. You're still on the same issue of you believe the court needs to recuse itself. But is there any other reason besides that why you cannot go forward with trial today?
Of course, Your Honor. So on October 25th, you cleared all courtroom and teams to get rid of witnesses. And you repetitively, 7th time in a row, refused to recuse, confirming your personal financial interest in this case.
So I'm going to interrupt you again because I've made clear that I'm not going to just allow you to use this courtroom as your forum, sir. The issue of conflict between yourself and the court has been addressed in writing, and we are not addressing it today. We are having our trial. I'm here since you have nothing else to present to the court as reasons why you can't proceed with trial other than your repetitive concerns about the court's ability to be fair. The court is instead going to turn to you, Ms. Roberts, and ask which specific issue did you wish to address today? Which specific issue do you want to start with? The spousal support issue, the stock? Where would you like to begin? Ms. Roberts, you're of course still on mute.
I apologize. I believe we cannot address the stock issue in detail, as at the last half-day trial, the court ordered Mr. Mars to produce documents regarding the stock, and I received one document from May of this year, and I have nothing showing the time period during the marriage, what may have been received. So I believe in general, we can have an order that any interest in the community stock is to be divided equally, and perhaps appoint an expert accountant to determine the community interest. But we don't have the documents or the information in order to determine how much money there is in community stock, as Mr. Mars has not cooperated.
Objection, Your Honor. Objection. First and foremost, we cannot proceed. And we cannot proceed. And second, Ms. Roberts was provided all my stock information, including screenshot of filters that I used, starting from the very beginning of stock program. And all the stock options were provided to Ms. Roberts. But again, Judge Flint cannot preside over this matter because of personal conflict of interest with petitioner, me.
Is there any further argument, Mr. Mars, that you wish to make on the issue of whether or not the court should grant the request to equally divide any community interest in the stock?
All community assets and debts should be divided according to equalization payment statement that was shared with the court and that states that respondent owes to petitioner $34,112.16. Those statements are shared with the court, filed with the court, and are included in evidence. But I state again on record that Judge Flint cannot proceed on presiding over this matter due to personal conflict of interest with petitioner. And this trial is illegal.
I'm going to object. It's non-responsive. It's a waste of the court's time.
And I do need to remind everyone, including myself, that we do have a hardworking interpreter here as well. So we need to pause and make sure we're not speaking too quickly because our court reporter and interpreter have tough jobs. The court agrees with Ms. Roberts that any community portion of the stock is ordered to be equally divided. If the parties are ordered to meet and confer to see if there can be agreement on the issue of which portion of the stock is community property. If they cannot reach agreement, the parties are ordered to hire an expert to determine the community's interest in the stock. The parties are ordered to, if I may, the parties are ordered to meet and confer on this issue within 7 days of the court's order. And if they cannot reach agreement, they're ordered to hire an expert to determine the community share. And the expert is ordered to be hired within 45 days of the court's order.
Your Honor, can you also order that the parties pay the cost of the expert equally and that once the amount is determined that it be paid within 10 days?
Objection.
Do you wish
I
to be
cannot
heard on
afford.
that, Mr. Mars?
Yes, Your Honor. Objection. We cannot proceed with this hearing because of a personal conflict of interest with petitioner in this case. Regarding splitting in half, respondent currently caused about $100,000 of financial damages. Respondent got all possible costs that she can get from me, and I have no any. Miss Roberts, please do not interrupt me. This is impolite. Please do not interrupt me. Please do not interrupt me.
Thank you.
Order.
Thank you.
Thank you, Your Honor.
So, Mr. Mars, Ms. Roberts, please go on mute. It's just too much feedback.
Your Honor, may I continue?
If I may, anytime either side objects, the other side is going to respect that objection, allow the court to respond to the objection, and it will not be viewed as an interruption. However, the court does find relevant Mr. Mars' position about finances and whether both sides are in a position to equally pay for the expert. So, Mr. Mars, please continue.
Your Honor, I kindly request that only respondent pays for all extra unnecessary costs. And looking at current situation, I do believe that respondent will have to pay punitive damages according to California Civil Code 3294 for $98,624. $98,624.47 of total financial damages, and I currently cannot afford any extra payments because you know that I cannot afford even renting home, and damages that respondent did by fraudulent restraining order signed by James Towery back in September 2022 caused irreparable damage that will last with me for about 15 years at best. Also, court was provided all my bank statements per September 15th, 2023, which means current bank statements, and all my latest pay stubs and all my information. And court knows very well that I cannot afford even court reporter in case where I'm going against judge who has personal financial interest in the case, an extremely unethical attorney who was twice requested by court to be disqualified for impermissible pressure on witnesses, emergency screener, professional supervisors, and
It exceeds the scope of the question and is non-responsive.
Sustained. So on the issue of finances, Mr. Mars, is there anything else you'd like to say?
I also would like to say that taking into account damages did by fraudulent restraining order that Ms. Mars did, I will also rather require sanctions by CCP 128.7 for frivolous motion.
Objection, non-responsive.
Sustained.
Issue.
Sustained. And so on the issue of ability to pay, do you have anything else to state, Mr. Mars?
All my bank statements are provided with the court in evidences to my trial brief. Fourth amendment. I cannot afford
Please go
any
on
payments.
mute. Mr. Mars, please go on mute so I can hear from Ms. Roberts without too much feedback. Thank you. Ms. Roberts, any final comments about who should pay for the expert if an expert is needed?
I believe the court should order it equally paid as it is. The court had ordered that the Quadro expert be equally paid, and Mr. Mars is not complying with that order. So ultimately, my client will most likely have to pay up front, but it will reserve the right for her to be reimbursed at a later time. So I do ask the court to have the parties pay equally.
So Ms. Roberts, is your client in a position to pay the full cost of the expert if an expert is needed to determine the community share of the stock?
I believe the parties' incomes are approximately equal, or Mr. Mars has income exceeds Ms. Mars, as he receives bonuses and stock that have not been paid. So I believe he's in a better financial position to pay, and all we're asking is that it be paid equally.
Objection, Your
The
Honor.
court does have it.
May I state?
What's the basis of the objection?
So, respondent and her extremely unethical attorney
What's the legal basis for your objection?
absence of any pay stubs or any proofs of income of respondent in court filings. Respondent never provided any
Your
income
objection is that's not a legal objection. Your objection's overruled. The court does have before it. Mr. Mars, please go on mute. Again, too much feedback. Thank you. The court does have before it an income and expense declaration filed on behalf of Ms. Mars on October 30th, 2023. In that income and expense declaration, it lists that she has no salary, but she does have $2,400 per month coming in as self-employment. The court notes that her expenses far exceed her income, and the court therefore finds that both parties are in a poor position to hire an expert, and therefore
objection, Your
the
Honor.
court again encourages both sides to meet and confer and reduce the chance that an expert will be needed for a division of the community of any portion of this community asset. But if an expert is needed, the parties are ordered to share in the cost equally.
Objection, Your Honor.
What is the legal basis for your objection?
This master filed with the court. It is evidence number 1 in a list of evidences.
Sorry.
Respondent is lying to court about not having income while she officially is full-time employed. She never provided pay stubs. She never provided proofs of income. Her average
Objection
salary
assumes
is
facts, not any
$148,000. Please do not interrupt me.
Sustained.
Is $148,000, and therefore, taking into account that respondent is receiving maximum child and spousal support possible, respondent is currently living much more luxurious life than during marriage, while renting a big house in Sunnyvale, being able to retain full scope representation attorney Ms. Roberts for more than a year of this case, which clearly confirms that respondent is in a very good financial position and can pay fully for any extra expenses that she
Objection
incurs.
calls for speculation.
Sustained. And Mr. Mars, I appreciate the argument. I appreciate your position, but the court disagrees. And at this time, the court has made the order with regards to the expert. And again, if the parties meet and confer and can decide based on the length of the time during the marriage that community property portion is agreed upon, there's no need for an expert. But if there will be an expert, there will be equal sharing of that cost. Ms. Roberts, the next specific issue you wanted to address today?
I'm sorry, Your Honor, could we just get an order that once there's been a determination, there'll be a payment within 10 days? We have problems with general orders.
Excuse me, what
Payment
is
must be made within 30 days of determination of the amount.
Excuse me,
Thank
what is the
you.
request? Ms. Roberts, could you please repeat? I didn't hear you.
The request, Mr. Mars, was that rather than just making an order that the parties meet and confer and hopefully come up with an amount, and if you can't come up with an amount, an expert will be hired. The request is once an amount is determined, that amount must be paid within 30 days of the determination of the community property amount.
Objection, Your Honor. As I stated earlier, I cannot afford even court reporter. And by your orders, you made me, practically speaking, starve to death for the next months because I will have to pay extra $200 for court reporter. And in my current situation, I cannot afford living. This can lead to me losing job because being homeless, being unable to pay for food, I'm practically speaking, I can lose job and respondent will lose maximum child and spousal support. And I kindly ask court to take into account my terrifying financial collapse caused by fraud and falsifications made by respondent and allow only respondent to pay any extra fees. Thank you, Honor.
Thank you. Ms. Roberts, your next request?
I believe the bank account, Your Honor. I would like to move in to have the court attention drawn to respondents exhibits G through K, which are the parties' bank account statements as of the date of separation. I would like to note that Mr. Mars has provided statements, but he's only included the first page, which does not show the details of the charges, and many times the statement does not end on September 15th, the date of separation. It is beyond. So,
Ms. Roberts, so this is a trial. If you want to share your screen and provide the court with evidence, you can do that, but we're not going to, you can't put the court in the position of going into each document electronically, listening to your argument, etc. You're either going to present evidence so that both sides can know exactly to which documents you refer, or you're going to present argument.
May I refer to the exhibits one by one, Your Honor? I was just trying
Certainly.
to.
Right, but I'm just trying to point out that the court doesn't have, both of you are choosing to appear on Teams. The court does not have hard copies of these documents.
Yes, Your Honor.
And so anytime either of you wants to court to consider a document, you're going to have to share your screen and identify which documents you're referring to.
Certainly, Your Honor. I'm going to have to locate that scan.
Your Honor, I will remind that due to personal conflict of interest between you, Your Honor, and petitioner on this case, this trial has no legal power, and you should resign from presiding over this case immediately. Thank you, Your Honor.
I'm sorry, Your Honor, it's going to take me a minute to pull that up.
While we have a spare minute, I would like to remind that by serious on consecutive harmful and wrongful orders, Judge Flint facilitated abduction of my son outside of United States, knowingly and intentionally.
I put you back on mute, Mr. Mars. As I said, I'm not going to allow you to just use this as your forum. We're in the middle of a trial. Ms. Roberts is looking for information about the bank accounts, and that's the conversation we're going to have.
Objection, Your Honor. This trial cannot proceed.
Darn it. Gosh darn it.
Ms. Roberts, do you need help? Maybe I can find necessary evidence and present it for you.
Do you have respondent's exhibit there? I would appreciate that if you do. I'm still trying to locate it.
Apologies, do you mean exhibits that were not served to me? And I asked
You
you
were
on September
served-
13 to serve them to me, and you refused in arrogant form. And it was captured and added to evidences for
Mars,
request to
you were
disqualify
served
you
before the
from this
trial in
case.
July.
Ms. Roberts, those were not served, and those could not be presented to judge in a court.
Calling out too badly, Judge. Understood. Thank you.
As far as I remember, all that was filed only list of exhibits, but not exhibits by themselves. They were never filed with the court. Mr. Roberts, I have a question. Are you looking something that was never existing?
Oh, shoot. Shoot.
Your Honor, Ms. Mars has requested a brief recess for herself to go get the charger. Okay, wait.
I have located it, Your Honor. I'm trying to pull up the exhibit now. I apologize.
And while I would like to remind that Judge Flint has obvious, undeniable, impermissible personal conflict of interest with me, petitioner, on this case, and is legally obliged to recuse themselves from this case, we cannot proceed with this trial legally.
Whenever you're ready, Ms. Roberts.
I apologize. I'm trying to locate the exhibit.
Your Honor, I would remind you that bribery of judge is punishable by up to 5 years in jail for judge and 15 years in jail for respondent
Mr.
who
Mars, please
facilitated
go back
bribery.
on mute.
I would remind you that this creates clear, impermissible conflict of interest
Please go
between you
back on
and me.
mute, Mr. Mars.
Thank you, Your Honor.
All right. I apologize, Your Honor. I'm not sure how to bring up the actual PDF.
Your Honor, I would remind you that by obliging the law and recusal, you can relieve
Oh, there it is.
life for
Mr. Mars,
everybody.
Mr. Mars, please do not. You have made your record clear. You don't need to keep repeating it. It's part of our record. And now we can see the document, Ms. Roberts. You may continue.
Yes, what is on the screen is Respondent's Exhibit G, which is a copy of, and I'm gonna do this by author of proof, is a copy of her Chase bank statement, account ending 5068. The statement is from August 19th through September 21st. The courts determined the date of separation was September 15th. On page
Objection.
2,
Your Honor, I would state the date of separation was September 1st, as it was
objection,
legally,
irrelevant.
it was legally
The
fixed
court-
by respondent's move-out notice. And order about September
Mr.
15th
Mars,
was made to
that's
commemorate.
not a legal,
Yes, Your
that's
Honor.
not a legal objection.
But I
Your
would remind-
objection's overruled,
Thank
and
you.
you'll have a chance to respond to Ms. Roberts' presentation in just a moment.
Okay.
Mr. Roberts, please continue.
Yes, on page 2 of this statement, circled, it shows the balance in this account on the date of separation, September 15th, is $585.63. And I request that the court move this document into evidence.
Thank you. So, Mr. Mars, do you have any objections to the court admitting Exhibit G, the document that was just showed?
Your Honor, objection number 1 is I do not understand what this means. What is the purpose of showing one bank statement from respondent? Because I filed, I think, about 25 or something. Should we go through all bank statements, Your Honor?
That is
So
not
the court is not going to, the court appreciates that you do not have legal counsel. The court appreciates that you don't have as much trial experience as Ms. Roberts, but the court cannot spend the trial explaining to you why each of the documents are either coming in or not coming in. The court is asking whether you have an objection to this particular document coming in or whether or not it should be admitted.
Your Honor, I have a question. Should we go through all bank statements of both parties to ensure a balance of assets and debts that was provided in equalization payment calculation sheet to the court, evidence number 28?
So the answer is no.
Thank you, Your Honor. Another,
The question that I've asked, you still haven't answered. At this time, do you object to the admission of Exhibit G?
that's okay. That exhibit doesn't say anything about balance of assets and debts, of community assets and debts. And there is another objection, Your Honor, that I state on record. That date of separation, September 15th, was ordered by you because of personal conflict of interest with me to commemorate memory of date of violence against minor child and an elderly person, 95 years old.
The
95
objection is sustained.
95 years old,
Put
senior
you on
person.
mute, Mr. Mars, and
Apologies,
the
Your
court
Honor, but date
is going to
September
find that
15th.
Mr. Mars is objecting to Exhibit G,
I'm
but
objecting
over
date of
objection, the
separation.
court is going to admit Exhibit G.
Your Honor, objection is about date of separation. This date commemorates violence of respondent against 95 years old senior woman with disabilities
Mr. Mars, I'm
who
gonna
was
invite you to
violently
go back
kicked
on
out
mute.
from home and turned into
Mr. Mars,
and
you
turned into terminal
repeatedly
condition.
unmute yourself and talk about issues that are relevant to the specific issue of the bank accounts. If you continue to do so, then eventually I'm going to have to drop you from the meeting and you will not have an opportunity to give relevant information about these bank accounts. So please, please focus in on the specific issue that we are addressing. Your general objection to the court has already been noted, and it's part of our record. But specifically on the issue of the bank account, that was a Chase account, Ms. Roberts, with $585.63 in the account, correct?
Yes, Your Honor.
Do you have any further evidence to provide at this time with regards to division of the bank accounts?
Yes, Your Honor, there's several statements. I'd like to draw the court's attention to Exhibit K, which is up on the screen. This is Ms. Mars, Bank of America, account ending in 5549, August 17th through September 15th. The balance on September 15th, as indicated by the statement, is $90.96. And I request the court to move this Exhibit K into evidence.
Mr. Mars, any objection to the court admitting Exhibit K?
We cannot proceed with trial because of personal conflict of interest between Judge Flint and petitioner on this case.
Objection, unresponsive.
And the court is going to, over objection, admit Exhibit K. Your next request, Ms. Roberts?
I'd like to draw the court's attention to Exhibit H. This is a Bank of America account ending in 8829 in the name of Mr. Mars that was produced as part of his production of documents. This statement is from September 13th to October 11th. On page 3, there was a deposit on 9/15. I'm sorry, give me one moment. So the balance in the account sorry, I don't have much control of the mouse. The balance in the account on September 13th was $1,441.08 as indicated on the first page of the statement. On September 15th, there was a $500 deposit from Mr. Mars Pay at EPAM Systems. So the total deposit on September 15th, the $1,441.08 plus the $500 deposit is $1,941.08.
Objection irrelevant.
Move the court.
The objection is overruled. And your next request, Ms. Roberts?
Yes, I request the court to move Exhibit H into evidence.
And Mr. Mars, any objection to Exhibit H being admitted?
Those statements were taken in the moment when I was completely unprepared for this court, and I provided only partial information. As far as I understand, we do not have any balances of community debts in those statements. Only
So,
community
Mr. Mars,
assets.
I'm going to stop you to say this. Ms. Roberts, go on mute, please.
Yes, Your Honor. So I would state
No,
that
Mr. Mars, hold on. Ms. Roberts, go on mute, please. Okay, so when the court asks you, do you have any objection to the admission of the document, that's not your time to explain how the bank account should be divided or to counter the information that's being provided. It's your time to state what legal reason the court should not consider the document. You're gonna have time. After she's presented her side of the bank statement, you're gonna have time to talk about your why the court should not adopt her request as to division of bank statement, division of the bank accounts. You're going to have time to do that. You're going to have time to show other evidence that you wish to show specific to the bank accounts, but now is not that time. The question is, do you have an objection to Exhibit H?
No, Your Honor. Exhibit H is just a very small piece of all the picture, and I would remind that because of personal conflict of interest between Judge Flint and petitioner in the case, we cannot proceed. Thank you, Your Honor.
Exhibit H will be admitted at this time. Ms. Roberts? You're on mute.
I apologize. Draw the court's attention to Exhibit I, please. Exhibit I is a Chase